The human rights conventions have been extensively disseminated in the Macao SAR through the aforementioned institutions and measures, and such rights are safeguarded through the highly strict monitoring mechanism. The government's performance in promoting and safeguarding human rights is watched over by the Legislative Council, the media, the NGOs, and the community at large. So, in our view, the existing mechanisms of protecting human rights have worked well, and there is no obvious need to establish another human rights institution to duplicate the functions of or supersede the existing mechanism. So, Mr. Chairman, this is my answer about the Human Rights Institution. Now, I would like to ask permission to pass the word to Ms. Chu Lam Lam to answer the questions. Then afterwards, I would like to ask Ms. Christina to answer some questions, and Mr. Zhu Lin to answer some questions, and then afterwards, Mr. Patrick and the representative, Mr. Nga Ken of our Labor Department, if the time allow us to have all these order of persons. Okay? Thank you, Mr. Chairman.
Thank you very much, Madam. Please go ahead. As far as possible, if your colleagues could be succinct so that colleagues would have a chance on the committee also to pose follow-up questions to the responses. Though, of course, we can go over into tomorrow as necessary. So with that, I hand the orchestration of the delegation over to you, Madam Chair.
Thank you.
Thank you, Mr. Chairman. Members of the committee, I would like to answer question issue 12 concerning the use of Chinese and Portuguese in Macau. Some members asked questions concerning some issues in our reply. In our reply, thanks to Law 101/99/M, all the laws have both Chinese and Portuguese version, and in the court, all the actions taken by the court, if it's taken in Chinese, there will be translation in Portuguese and vice versa. Therefore, I think the answer to this question is clear. However, member of the committee asked whether in the court, in the legislative and executive branch, the use of two languages are guaranteed. If that is the case, that means that residents in Macau are bilingual. They can use Portuguese and Chinese. I would like to provide such information to the committee. The majority of the residents in Macau, maybe 90%, only speaks Chinese and not Portuguese. The residents, bilingual residents, is a very small proportion of the population. Even so, the government of Macau SAR spends a lot of resources to make sure that the Portuguese residents or the residents speaking Portuguese in Macau can have information. If they request information from the government, translation version will be provided by the government. Of course, this is being done in consideration of the history of Macau. Macau, as a region with a Portuguese language history, it is also a platform for Macau SAR to engage and cooperate with countries speaking Portuguese. We will continue to cooperate with these countries and to promote exchanges and cooperations with these countries. So at the moment, not only in the universities where courses in Portuguese is provided, the government departments, for instance, the Office of Administration and Justice also provide training in Portuguese. We also have cooperative projects with EU to give training course in Portuguese. Recently, the Macau government adopted a program for the salary, a special salary scale for the translators of Portuguese in order to encourage more people to speak and to use Portuguese. Thank you.
Good afternoon. I will address a number of issues. I will start with issue number 2, raised by the distinguished member, Mr. Fitterman, regarding the application of international conventions in Macau and the hierarchy. Mr. Kalin, sorry, by the distinguished delegate Kalin, regarding the application of human rights conventions in Macau and the hierarchy in Macau legal system. International conventional law is a source of law in Macau, and according to Article 1 of the Civil Code, it has supremacy under ordinary law, which means that in our hierarchy of laws, we have the basic law, which is our constitutional law, and then we have international conventional law applicable to Macau. The application of international law just need to be published. To have effect in Macau, we just need publication. So we have a civil law system, and we still maintain the characteristics of being a monist system. So we have the basic law on the top of the hierarchy, then we have the international conventional law, and then we have ordinary law. Every time ordinary law contravenes or enters into conflict with international conventional law applicable to Macau, international conventional law prevails. So, that said, as previously was explained, some articles and provisions of the Convention have been raised in court, and the court has been taken into consideration. But until now, we have faced no situation or concrete situation where there was a direct conflict with international conventional law. But if it happens, the judge will apply the law and the hierarchies of our law. Regarding how do we explain and how Article 40 of the Basic Law and what does it mean that the ICCPR is going to be applied to local or ordinary legislation. As we know, the ICCPR has some articles and provisions which have to be implemented to national or local legislation. They are not all self-executing, and so we have programmatic provisions. And of course, those programmatic provisions have to be enforced to domestic legislation. So this means that, first of all, the ICCPR has constitutional value because the Article 40 is constitutional law. And apart from that, the programmatic provisions from the Convention is applied to national legislation. For example, freedom of expression of thought and of the press, we have to have the press law. If we have freedom of association and we have limits to that freedom of association, then we have to have the law on the association, and so on and so forth, and as explained in the report that we provide. So there are provisions that, even though there are provisions that are self-executing, for example, as a prohibition of torture or of slavery, of genocide, because they are also customary international law. So this, I hope I cover the spectrum of that issue. Regarding reservations to Article that were made to Article 11 and 12, if I'm not mistaken, to 12, those reservations that were made are reservations exactly that allow, when we have a restriction, on the full enjoyment of the right, then we have to do it and by law, because we have the rule of law and the primacy of law in our legal system. And so, in case we have some restrictions, they are only done and enforced through local legislation. Again, that will not contravene and cannot contravene the ICCPR being ICCPR as a whole, constitutional law as well. Regarding some comment that was made that we don't have legislation regarding sexual harassment on labor. We have a provision on our criminal code that speaks about sexual harassment on labor. However, we don't have the autonomous typification of the crime of sex harassment for labor, which is different. Although we don't have the autonomous typification, it doesn't mean that we don't have in our legal system, in our criminal law, legislation to punish workers or a situation where women or men eventually can be subject to sexual harassment on labor. And we have provision on now Criminal Code Article 171 that says that all the articles from 157 from our criminal code that covers crimes against sexual liberty or freedom, that covers crimes against sexual autodetermination, all of them are punished and are aggravated if the person that provokes sexual coercion or rape or any kind of sexual abuse are aggravated if the person has a dependence, hierarchy, economic or labor with the offender, with the victim. So we have such provision, but not as an autonomous crime. As regard issue number 13, also raised by Mr. Kalin, there is no interregional agreement on the surrender of fugitive offenders between Macau and mainland China. And this understanding has been upheld by the last instance court, namely through two court decisions, 12-2007 and 13-2008 of habeas corpus. The court decided that individuals detained by the police, they were Chinese nationals and they were non-residents of Macau, should not be sent to mainland China since there is no interregional agreement on the subject. We can say, however, that currently there are negotiations with mainland China and Hong Kong as are on the drafting of international regional agreement on legal cooperation in legal criminal matters. That said, we can never send anyone, or we don't have deportation, no extradition, because this is a relationship between China, mainland China, and Macau SAR, which is a special administrative region. And so, according to our law, it's not possible to send or to expel, let's say, this word, someone to mainland China just because we don't have that kind of agreement. This means also that the person, that there is no, we cannot say much more than what I just have said regarding this issue. Regarding terrorism, issue number 4 raised by Ms. Mutok. Our internal security law prescribes very clearly in which circumstances a person cannot enter in Macau. And one of the reasons we cannot enter in Macau is precisely if there is a threat to internal security, or if the person is referenced as a suspect with connections to transnational crime, including international terrorism. This means, of course, there is a sharing of intelligence between the police forces with foreign counterparts. There is also the Interpol information, and there is also the United Nations Security Council resolutions also on terrorists. So if a person is identified based on that intelligence, on the intelligence information, the person cannot enter in Macau because he's a suspect of terrorism. If the person is classified within the Interpol lists as terrorist, is analyzed as a terrorist, it will be detained and sent to the Interpol. So, which means on this situation, yes, we have a limit to the freedom of movement because that person can be considered a threat to Macau internal security, and therefore it will not enter in Macau. Regarding the state of emergency, as we explained in the list of issues, there are certain rights that can be restricted in case of state of emergency. But those rights, they have to be, before the restriction being ordered, we have to balance the necessity of the case according to the circumstances. We have to balance the proportionality of the measure, and we have to balance also the adequacy of the measure. According to our law 9/2002, such restrictions can only be made or ordered based on the. Sorry, just a moment. Those restrictions can only be made after that assessment, and they have a temporal limit of 48 hours. Those restrictions are, according to Article 17, to allow police surveillance of persons, buildings, and premises for a limited time period, to ask someone's ID whenever is in a public place or under police supervision, to seize temporarily arms, munitions, and explosives, to refuse the entry of non-residents, or to expel anyone who poses a threat to the internal security according to circumstances. These are provisional measures that have a temporary limit of 48 hours, and they have to be, in case they are going to be prolonged, they have to also be consulted the Legislative Assembly and also the Council. These provisional measures do not contravene with the ICCPR provisions because there are limitations, especially to the freedom of movement and to the basically they are around the freedom of movement or some surveillance regarding some privacy issues that can happen if you take into account the measures. But those measures are limited to 48 hours, as we explained. We cannot impose a restrictive measure, more restrictions than these ones, because these ones are the only ones provided by law. As such, and also take into consideration that the law on security also expressly stated that we have, before implementing these measures, we have to take into consideration Article 40 of the Basic Law, which goes again to the ICCPR provisions, means that all the rights and freedoms that are non-derogable, that cannot be restricted, have to be respected. This means that even the ordinary law also reiterates what it says, the Basic Law regarding Article 40 and the application of ICCPR. For example, no one can be subject to torture, no one can be subject to a situation, cannot be respected as a human being, and other provisions of the Convention that cannot be derogable, they cannot be derogable also through the internal law security when it's enforced. Regarding issue number 5, and a question raised by Mr. Fitterman, and how that academic question that we don't have yet the application, there was no case. Well, the law on internal security, again, allows the possibility of doing some going to computer access and also taping some suspects only when they pose a threat to the Macau internal security. Again, I want to stress that it's only when they pose a threat to Macau internal security. In these circumstances, when we tape or record communications between individuals under the threat, Macau being threatened on its internal security, this can only be done through a court order, which means that the court supervises the request from the police that there is a matter of internal security that is being threatened. The balance between the necessity, adequacy, and proportionality will be judged and assessed by the court, and the court order will be issued, which means that the suspect at that situation this right is being ensured by the assessment of the court order. If the suspect is confirmed to be a suspect after the taping of the record, then he will be constituted as a defendant, and then he has his criminal rights ensured, procedural rights according to the Criminal Procedure Code. As a defendant, as access to lawyer, to the proceedings, to appeal, and so on, after being indicted as a defendant. In the meantime, I should also highlight that the data protection law also makes an exception precisely for these situations. When we have a situation of a threat to internal security, then we have an exception regarding the access to information or to the the right to inform the person that is being under surveillance or under in a situation of surveillance on data or on tapping his phone records or whatsoever, because that is a threat to internal security, and that exception is also foreseen in the data protection law. I have more. Regarding I think I still is missing one. State of emergency. I don't know if I have something on state of emergency. At this moment, I think I don't have any more. Regarding the issue that came from the court decision about the impartiality of the criminal judicial procedures, this I'm referring to question number 2 of Mr. Kalin, if I'm not mistaken, and paragraph 13, where we speak about a court case and where do we have an impartial and a fair trial system. The case, it's a case of a suspect that was libel or made slander against the director of the Judiciary Police. According to our legal system, the Public Prosecutor's Office is the entity in charge of the investigation of a crime. And the Public Prosecutor's Office has as a second hand the Judiciary Police to do the investigation, supervised by the Public Prosecutor's Office, which means that it was the office, the Judiciary Police, together and under the supervision of the MP, of the Public Prosecutor's Office, that made the investigation, and in the end it proved that there was that the suspect was wrong. But of course, the entity is the Judiciary Police, but the person that did the investigation, that the gathering of evidence, it was of course not the director or the head of the Judiciary Police. Now, he should not be penalized because of his position of being the head of the Judiciary Police, that he cannot be penalized of being on that situation, on that position, on that high ranking. But the impartiality was assured through the fact that it was the Public Prosecutor's Office, which is the MP, that conducted the investigation, and it was also with the support of the police officers of the Judiciary Police. This is our legal system, how it works. If by any chance the suspect had claims or complaints that this would not be a fair trial because investigation was not conducted in a fair way, there is always the possibility of going to the ombudsman person and making complaint, and also to raise a complaint at the Public Prosecutor's Office regarding the eventually non-fair collecting of evidence. But I must say that it was an unfortunate event, since a person to be defend himself being on that position could not be defended just because he was on that position. So this means that the fair trial, the prosecution did the best according under the supervision of an independent and autonomous entity, which is the Public Prosecutor's Office. Regarding still one question regarding issue 11 that was raised by Mr. Ashur regarding the prison establishment and the number of other disciplinary measures that are applied to prisoners. We have the data with us. This data was provided in paragraphs, from paragraphs 2.226, page 34, to paragraphs and page 35 of the report. We can update such data. Maybe I'm not going to enter into detail about the numbers. Maybe it will be easier if we provide to you in writing the detail regarding the other measures that are applicable to adult prisoners in the Macao prison establishment, and also the difference of those application of those measures. I can say to you that we have now around 1,112 prisoners in Macao establishment as a whole, and we'll provide you more detailed data in writing if it's possible. Thank you.
Thank you, Mr. Chairman. I would like to take some other questions now. Question from Madame Shina. I hope my pronunciation of the name is correct. Mr. Shina, actually. No, sorry, it's a Miss HRCtte. Sorry, apologies from the interpreter. So my question is about, my answer is about the question from her concerning the legal interpretation of the Basic Law. To put it concretely, it concerns Article 143 of the Basic Law. I believe, because you've been through with the report of Hong Kong, and this is probably the most important reasons why you're interested in such an issue. My answer is as follows. First of all, let's take a look at Article 143 of the Basic Law that provides that the interpretation power belongs to the National People's Congress. It's standing committee of the NPC, in other words. Why does it say so as a provision? Because the Basic Law is a national law. It's not a law that is adopted by the Macao's Legislative Assembly. So according to the tradition of law, legal traditions in China, and the practices thereof, the National People's Congress has always had the right and power, rather, to provide interpretations to the laws that it passed itself, for the purpose of guaranteeing the fact that the enforcement officers of the law will understand the correct meaning of these laws. Let's look at the second sentence of this provision. The Standing Committee of the NPC authorizes the courts of the Macao SAR in treating cases concerning those clauses within the self-administration authorize the latter, in fact, to give their own interpretation, in other words. I think the meaning of this provision is that because the Article 83 of the Basic Law provides that the courts of the or Macao SAR can have independence in its judgments. They're only subject to the laws. They're not to be interfered by any other elements. But I believe, respectable members of the committee, you should fully appreciate the fact that in making decisions at courts level, it is unavoidable that the laws they try to apply will be unavoidably interpreted by these courts. Therefore, when this happens, in accordance with paragraph 2 of Article 143, the courts are allowed to provide interpretation to the things that are directly under the administration of the region of Macao SAR, instead of making a special authorization from the Standing Committee of the National People's Congress on these matters. To put it more simply, I would say, in fact, the interpretation power of the Basic Law is from a combination of the Standing Committee, or rather the NPC, and these courts in Macau. So they both have the power to do interpretation of these laws. As to some specific cases, I would like to make a following clarification. As of now, in Macau, there has been no situation indicated in para 3 of Article 143. So, in other words, there is no such a situation that a demand has been made, submitted to the National People's Congress for interpretation. Such things have never happened, in other words. So if you want to understand more about the procedure concerning this matter, my understanding is that according to this provision, the final court of the Macau SAR when it comes to the affairs directly under the administration of the central government based on the Basic Law, if they are to make interpretation concerning these matters, or when it comes to interpretation concerning the relationship between the region and the central government, when that happens or occurs, then, first of all, it has to go through the administrative officer, the chief administrative officer, executive officer, rather. I'm sorry, says the interpreter. A submission then is submitted to the NPC, Standing Committee. The time has to be such that the court has not made any final decision on the case in question. When that occurs, the Standing Committee of the NPC comes up with an interpretation, and then at this timing point, the court should follow this interpretation from the NPC and then make a decision by implementing this decision and this interpretation. Thank you. Good afternoon, Mr. Chairman and members. There is a question from Mr. Atauer and Mr. Waterfall. They raised questions concerning domestic violence. I would like to give the following answers to their questions. First, in order to prevent domestic violence and to strengthen the protection for victims and the counsel on the perpetrators, the government of Macau has come up with a draft of preventing domestic violence, the text of which was deposited last year. So we're in the last stage of cleaning up of the text. By the end of 2013, we'll submit that to the relevant authorities for reading. And when the law comes into effect, there will be a strengthened protection of the victims. At this stage, in this stage of the draft of the law that is going to be completed, there is a clause concerning the counseling of the perpetrators. So the perpetrators will not only be punished according to the draft, but also will have to accept the counsels. So that in doing this, they will understand that it's a wrong action to have committed domestic violence.
As to figures on cases of domestic violence in 2012, the children victims of domestic violence is only of 1. But we will act according to the past statistics of several years. We know that in the past, the SAR government has worked in such a manner that we have worked very hard to reduce the number of victims. First of all, we have made public consultations on the Prevention of Domestic Violence Bill, which has raised awareness among the public on the protection of victims, including children. Secondly, last year, the government has raised awareness on the CRC, and we have had campaigns on children's rights, including their right to life, their right to be protected, to develop, and to participate. We have used many publications and awareness-raising materials to support NGOs to conduct such campaigns. And such campaigns have raised awareness of the public of awareness on children victims. Starting from 2012, and in cooperation with NGOs and the civil society, the government's relevant authorities have conducted campaigns in many communities on a happy life and a happy family. We would like to raise an awareness on the importance of a harmonious family life and to encourage parents to provide more care to their children and to refrain from using violence to solve problems, if any, and especially to abandon the mistakes of using corporal punishment on children. I think I have done with the question on domestic violence. Thank you.
Good afternoon. I would like to answer the question on equal pay for equal work between men and women. According to the statistics in our report, we can see that in 2012, women account for 48% of the labor force in the SAR. And I would like also to raise some figures for your consideration. In 2012, women account for 41% of the total public servants. And in some local government, legislative assemblies or bodies, women account for 40%. And in the judiciary, 44%. In teachers, 47%. And the legal aid, over 50%. And maybe the figure is a little less for the police department. And in total, the figure stood at 42%. So we can also use some figures from the Statistics Bureau. The participation in labor force by women have raised from 55% now to 67%. And women also are leaders in social organizations and other leadership levels. This figure have been raised from 3,700 to more than 5,000, and at the same time, the men's figure, the increase was only 500. That means that women's participation has been 10 times increased than that of men, which shows the rapid increase of women in position of leaderships. Now, as to remuneration and equal pay for equal work, there are also some figures. On the median figure, in 2001, the median figure was for men 10,000 pataka and 8,000 for women. And the most difference is shown in manufacturing sectors. But we can see that in other areas, entertainment, service, or the tertiary sectors, there are very little difference between men and women. If there is any difference in pay between men and women, you can also see the narrowing of such gap. In 2009, the figure for employees from men and women is 70%, and now it's the figure has been raised to 77% of the remuneration in terms of men and women, the ratio of men and women. So we can also see the reducing gap. As to the question mentioned by some members that some women prefer to stay at home to be caregiver, we can also see that in order to subsidize some low-income employee, the government has promulgated an interim measures for subsidies for those over 40 years and permanent residents. And if they work more than 152 hours per week and with less than 4,000 yuan, then the government will bridge the gap between this and the normal wage level. As to temporary sectors, such as garment or other sectors, we also have other measures. This is because some women prefer to take care of their family members and take on some temporary jobs, and in such case they can also apply for subsidies from the government or allowances. As to what was mentioned by some members of our figures of 2009 and to 2011, there are no complaints in Labor's Bureau. This concerns the non-resident workers, and it is not because there is no case at all of complaints. It is just concerns the non-resident workers. I don't know whether I have been correct in understanding your question. Thank you. Mr. Chairman, distinguished members of the committee, I would like to supplement information as follows, and to provide more information on what colleagues have said just now. I would like to make clear that on the interpretation of the basic law, in the Macao SAR, there has never been the case where we have sought interpretation from the National People's Congress as to a court judgment. This case has never happened, so I would like just to make that clear. As to the application of international law in the Macao SAR, just now my colleague has provided his explanation also. In our judicial system, this is the same case as with other continental law countries such as Portugal. The international law directly takes on effect in our domestic law without having to enact domestic law. It is only just through the official gazette from the government publishing the relevant international laws and treaties. When it has entered into force for Macau, then the law, the international law, is in force in Macau. Of course, some provisions of some international law may have to be detailed in domestic law enactment. For example, in the ICCPR, it was mentioned the freedom of association, of protest, etc. Such freedom can be invoked directly. But as to the administrative regulation, the detailed administrative regulation on how to form associations, then we need to have local laws for the detailed provisions. And we have to provide for administrative regulations. But that does not mean that rights enshrined in international law have to be provided in domestic law for it to be entered into force. It all boils down as to whether we have to have detailed provisions on how to implement some rights. As to a case mentioned by a member, 792/2010, which is a criminal case, which is a case of appeal. In this case, for example, the suspect directly invoked Article 14 of the Covenant. In his defense, he directly stated that article for his defense. he argued that the libel victim is the director of the judicial police. And so in this case, he deemed that when Article 14 of the Covenant states that all persons shall be equal before the courts and tribunals, then there was a violation, as he claimed. The final court made a final ruling, and which stated that the suspect can, of course, invoke this article of the covenant. That was not a problem. He could very well invoke that article, but it's ruled that the court decision did not contravene the covenant, because the investigation in Macau has been conducted by the prosecution's office and also by the judicial police, and the final court decision stated that the suspects lost the case, but did not say that they could not in the first place invoke Article 14 of the Covenant. That was my supplement to the information provided just now. Thank you.
Thank you very much to the delegation for all those detailed responses, and I'm sure colleagues were particularly appreciating the more concrete elements that we were getting at this stage, which is making this dialogue particularly constructive. We have a few minutes left, and so I now invite colleagues who wish to pose follow-up questions to indicate their wish to do so right now, and if we can't get them all out of the way tonight, we'll continue tomorrow. Mr. Kalin, you have the floor, sir.
Thank you, Mr. Chair. Taking into account the late hour, I just collectively would like to thank for all the responses provided without going into details. I just have some additional issues regarding issue number 2, issue number 3, issue number 3, the human rights institution. My concern was not the absence of all the mechanisms you described, but rather the question of whether they are sufficiently independent. And you are aware of allegations or reports about insufficient independence. I would like to have your comments there. Then I also had asked for more precise information about the human rights role of the Commission Against Corruption and the Ombudsman. And I wanted to know, are they looking into human rights issues that are not related to the corruption issue? How often did they do it? So if you could tomorrow provide me some information on that. I'm on issue number 2. Thank you again for the clarifications. I'm also coming from a monist country, very familiar with the system. I had also asked a question regarding the reservations and whether you are looking at them. Maybe I missed the answer, but I didn't get that. And finally, regarding issue number 13, I'm satisfied with the answer that right now transfers are not possible, even though one would expect, and still even as an autonomous region being part of a country, that transfers would take place. So you tell me that there will be an arrangement for interregional transfers. I would like to know a little bit about your approach to those negotiations, again, in terms of safeguarding the covenant. And I mean, the key issue, of course, is death penalty. Thank you.
Thank you, Mr. Kalin. Are there any other? Yes, Mr. Matadin, you have the floor, sir.
Thank you, Mr. Chairman. I'm thankful to the delegation and especially to Ms. Chu Lam Lam for the information that they have provided in relation to a query from my colleague, Mr. Benacho, in relation to official languages and translation. However, when it comes to the laws passed by the Legislative Assembly and to judgments delivered by the Court of Final Appeal, we have had a different tune from some NGOs. It has been suggested that the translation that is being made is of a very poor quality. Maybe the delegation may wish to give some comments on this particular issue, please. Thank you.
Mr. Shani, you have the floor, sir.
Thank you, Mr. Chair. Thank you. I want to thank the delegation for the very comprehensive answers and to congratulate them for the very constructive spirit with which they are conducting this dialogue. I have a follow-up question on issue number 6, actually, with respect to inequalities in the labor market between men and women. And I have before me statistics that are 10 years old concerning the number of women who are business owners. The statistics that I have cite a very low percentage, about 1%, 1.3% of businesses being owned by women. And I was wondering whether the delegation can indicate whether this is a problem in Macau, and if it is perceived as an issue, whether any steps are being taken in order to encourage women to become more prominent in the field of business ownership. Thank you.
Thank you, Mr. Shani. Maybe just to save time, I'll permit myself one question in relation to the case, the defamation case against the Chief of Police, case 792 of 2010, that has been referred to on a number of occasions. I hope I've understood correctly that the police involved in the investigation were not the Chief of Police himself, were not the alleged victim. That's very important. But of course, when the alleged victim is the head of the organization in question, there still is the possibility of an aura of influence pervading. And so it would be very interesting to know if any measures were taken to ensure that those police, albeit under the authority of the prosecutor, were in fact feeling free to investigate as would have been appropriate. What kind of measures would be put in place in such a situation? What kind of measures were put in place in such a situation? And with that, I think we can call it a day, and thank you very, very much. Yes, of course. Before I close the session, I'm going to give the Secretariat the floor to make one or two announcements. You have the floor, Ms. Fox.
Thank you, Mr. Chair. Just to confirm to the members of the committee that your meeting with Mr. Salama, as referred to in the Bureau minutes of last week, will take place on Thursday of this week, so that's the 21st of March at 2 o'clock. And we will have some informal interpretation from our colleagues for those who wish it. And then secondly, with respect to the committee's dinner or reception, we have not received as yet an expression of interest in a dinner at this point. So we are going to book the reception, a cocktail reception in the Epsom for Thursday again, so Thursday the 21st of March for this week. And the question of having a dinner at some point will be brought up again in the Bureau. But for the moment, it's a reception in the Epsom on the 21st of March, on Thursday of this week, and we'll let you know the exact date later on. Thank you.
Thank you very much, Kate. Thank you very much, delegation. Thank you very much, the interpreters, all those who are attending and following our proceedings. The session